Hello, welcome to this recording. Thank you very much for joining us for this. I am Alistair Holzhauer-Barrie, one of the partners here at Gill Jennings and Every. As well as being a design attorney, I'm a European patent attorney and a UK patent attorney. Over the course of my career, I've been involved with the filing and prosecution of several thousand designs, both in the UK and Europe, and as well as involved in strategy points around designs and freedom to operate and enforcement matters. And I'm joined by another of our partners, Luca Colombo. Luca, would you like to introduce yourself?
Yeah, thanks, Alistair. Hello, I'm Luca Colombo. I am also a partner here at GJE. I'm an Italian and European trademark and design attorney, and as Alistair, I've been involved in quite a few thousands of design matters during the course of my career, particularly European design matters.
Okay, we're going to move on to Luca's going to introduce what we're going through today, and then we can make a start from there.
Yes, thanks again. So, what we are aiming to do today is to provide a brief overview on the upcoming changes and on the upcoming design law reforms. What you can expect from our presentation today is an overview on the timelines of the reforms, and we'll try and we'll try and talk you through all the phases of the reform, as well as reviewing the substantive updates and the modernizing reforms. We will talk about the new definitions of brought about by the laws in terms of validity, and all the modernizing changes in terms of filing and prosecution and enforcement, including a brief analysis of the new repair clause and an explanation of the adjusted fee structure. Right, so let's see what is being reformed. As you may know, the reform is based on two main legal texts. One is the regulation, and the other one is the directive. The regulation aims at reforming the unitary EU registered and EU registered designs, and will be accompanied by secondary legislation, which consists of implementing regulation and delegated regulations, whereas the directive aims at reforming the national laws of the EU member states, while a regulation is directly applicable, and so it will, a first part of it will come into force on the 1st of May 2025. The directive has first to be transposed into national laws of the EU member states, and so we will see changes coming along in a couple of years. So yeah, the timelines are now on screen. As I was saying, first one of the EU regulations will come into force on May 1 or May 1st, whereas the phase 2 of the regulations, so which will put the regulations in full effect, will come into force on July 1st, 2026. The directive, so the national laws, are supposed to be implemented and be enforced by the 9th of December 2027. Just another couple words on the reforms that are being brought about. So, what was the aim of the legislator? The aim of the legislator was that of harmonizing design law across the European Union, so on unitary level and also on national level, and aligning the design laws and procedures to other IP rights, and in particular to trademarks, to EU trademarks, and also to modernize the scope of protection and the and procedures and means of protection to the current business. Right. Phase 1 reforms are the first one who are coming up, and so we will focus on those in the course of this presentation. We thought it would be sensible to start off with what is not changing. So what is not changes is the essence of what is protected and the essential features of of designs in the European Union. Novelty and individual character will remain the main requirements that for obtaining protection in the European Union. Examination of the European designs will remain limited to formalities only. The exclusion, so what is excluded from the scope of protection, will remain the same, and we will get to that in the course of the presentation. The term of the European register and the register design remains the same, as well as the minimum rights conferred in the EU. Now, what is it that is changing? Well, quite a lot is changing, and Alistair and I thought we would provide you with this sort of visual representation of some of the amendments that are coming up. We are not going through all of them in detail. No need to worry about that. We will only focus on the main ones. Probably the most visible ones are what we like to call the cosmetic changes. So the cosmetic reforms are that all references to community, which were a bit old-fashioned now, are being replaced to EU. So as of 1st of May, we will officially be handling with registered and unregistered EU designs. The new regulations will be renamed to EU design regulations, and it will be the same for all, also for secondary legislation that will come up next year. So basically all references to community are being replaced to European Union. Another important cosmetic change is that the legislator has introduced the design registration icon, which you can see on screen. So design owners will be able to use, if they want, this icon to mark their registered designs. Some of the existing procedures which are already in place but are not so far are not codified, are being codified, and so they are being put down on words and on paper, and they have made it to the regulations. And as I mentioned at the very beginning, some of these codification aims at aligning the design regulation particularly to trademark regulations. So there is a lot we know about what is coming up, and again, we are trying to provide some insights on what we know. There's a lot we do not know yet, and the EU IPO itself does not know yet of the changes that are coming up, particularly of the changes that will be introduced in phase 2 in July 2026. These include, for example, the effective number of drawings that we will be able to include in an application, the scope of the application. It should be possible to amend views and drawings after the filing date, which is currently not possible, and it will still remain not possible after 1st of May. But changes should come up next year. We also know that there might be new limits to cost of words, particularly in connection with invalidity procedures, and new representation formats will probably be introduced. We do not know yet, as I was saying, how this will all play up, but we are constantly looking into, we will keep looking into that, and we are in direct contact with the EU IPO, and so we will provide further updates as and when these are being made available. Right. As I was saying earlier, we will now go through the new definitions of validity. So, Alistair, do you want to guide us through that?
Yes, thank you very much, Luca. So we thought that we'd break down the reforms into three broad sections: validity, which I'm going to handle in a moment, and then we're also going to talk about filing and prosecution and about enforcement as well. So start out with the validity side of things. The core of European designs, the core of that right, is built around two definitions: the definition of what a design is and the definition of what a product is. We're going to look at both of those because both of them are being amended, and we'll go through what those amendments mean in reality, in practice. So you can see here as on screen now that the definition of what a design is being amended to add in that as well as covering the appearance of the whole or part of a product, the results from the features, a design is also going to include decoration of a product as well as movement and transition and animations of the features. You can see that this text is being put in place of the word ornamentation with that being removed. So it appears that this is intended to be a swap of some of the older language with some of the newer language. Moving on to what the amendments are for the product definition. You can see that this is a bit more extensive than the changes to the design definition, and this adds in that as well as a product being a physical product, it's intended to cover non-physical products as well, but also covers packaging and sets of articles as well as arrangements, both of an interior and exterior space, as well as being a bit more explicit as to the use of graphics or graphic works, logos, and surface patterns, and explicitly now including graphical user interfaces. Some of this is just a bit of a changing around. You can see that the word packaging has moved from one part later on to slightly earlier on, and get up, and what that is intended to mean is likely now covered by the spatial arrangements mentioned. And you can see that exclusions for computer programs, which as far as we understand it is exclusions of things like code that implements a particular appearance on screen and things like that. That exclusion, that mention of it being excluded is now moved much earlier in the definition. So it's not intended to be a change in practice on that point. And speaking of what really is intended to happen here, what it means and what these changes mean, there is an underlying intention that the changes to the definition do broaden what the definitions are. However, we're going to be somewhat reliant on what legal cases are brought and how the new definitions are tested in courts. So it will be dependent on the case law. So it'll really come down to what the interpretation is. And we'll look at some examples that the EU IPO have given on the next slide to that they've tied to these definition amendments to help sort of show you what they're intending for this. What it does really bring, though, these changes is that it brings in references to virtual reality and augmented reality much more, showing that those are relevant and talking about transient elements, things that change in the design or in the product that the protection is being sought for, as well as there being non-tangible physical arrangements such as lighting effects. In terms of what will change in practice from May 1st, there's not really, we think, going to be any particular changes that we see now. As we get updates more for when we come into phase 2 in July 2026, with the possibility of new electronic formats for what files can be used, what representations can be provided, we may get some evolution. But for now, it's more just bringing the definitions up to date over what we currently have in place. Right, so looking at some of the examples, on the left-hand side here, we have the example of a spatial arrangement, so an interior lecture hall by the look of it. And then at the bottom left, we have a lighting arrangement of some lights on some walls and a pillar and how they shine light onto surfaces. Now, those are intended to be covered by the broadened definitions, but as you can see by the acknowledgement of those images on the image, those are already European registered designs under the existing system, the system before the reform kicks in. So that shows that that's possible now and before the reforms kick in, as well as being possible after the reforms take effect. On the right-hand side of the screen here, we have some examples that the EU IPO are using, but aren't existing registered designs. So the building in the top that, as I believe, is likely a representation of a church, there will be changes in how the lighting and the appearance of that room is over the course of the day as the lighting conditions change, as the weather changes. So that's intending to show that there can be some transient element in this. And the image on the bottom right is of a projection of a keyboard. Now, my view is that you could likely seek protection for the keyboard itself without the projector before the reforms take effect. But the EU IPO are definitely intending this to be covered after the reforms take effect without the projector. So just this, just the representation of the keyboard. That is likely they're trying to shift towards things that can be done in other jurisdictions, such as in Japan, where you can already cover projections without having to cover the projector itself as well. So you can see none of this really is particularly groundbreaking, but they are sensible things that owners of designs will want to possibly seek protection for. So the EU IPO, the office governing the application process, is seeking to allow owners of IP rights to protect them through registered design protection in Europe. One of the areas where we're getting some more amendments is on the definition of what the grace period is, which allows you to discount certain disclosures from the prior art that are made in the year preceding the filing of an application for a registered design. The changes we're getting here is that any disclosure must either be identical or not differ in its overall impression. So have the same overall impression, same individual character as what later goes on to be registered, or for an application to then that later goes on to be registered, for it to qualify for exclusion from the prior art under the grace period provisions. This limits the disclosures that would fall within the remit of the grace period, and so what can be removed. What this does is it clarifies the limits on the grace period. Historically and previously, we've had three options available, three broad interpretations. One where the interpretation was that your disclosure had to be completely identical to the design that you later went on to apply to have registered for it to qualify for the grace period. At the opposite end of the scope of what could be interpreted, it was that any disclosure, possibly not even any related disclosure, would able to be discounted as long as it was a disclosure made by the party that later went on to file the application or a related party. What we've arrived at is some middle ground of it being any disclosure having to be identical or have the same overall impression. That's probably quite a sensible interpretation to take, because it matches the grace period provisions to the overall validity requirements of having to have novelty and individual character to get something registered validly. This also means that it brings the EU into alignment with the provisions that are now prevailing in the UK after the Marks and Spencers and Aldi case that went through the High Court and the Court of Appeal in the UK over the last few years. In that case, they delved into quite a lot of detail as to what the right interpretation of the grace period provisions was, and they arrived at the same conclusion here as has been put in place for the EU reforms, that it was identical and the same overall impression. To lead you through a bit of an example here, the right-hand image is one of the two images that Marks and Spencers got registered as part of a design in the UK, whereas a grace period disclosure by Marks and Spencers is the bottle on the left. Now, as part of those court proceedings, it was considered that that left-hand bottle was not identical and had a different overall impression from the bottle shown on the right. And so through the decision on what the limits on the grace period were, that was considered to fall outside of the grace period provisions, and so counted as prior art in the design corpus applicable to the registration. Now, because it was considered to not be identical and not have the same overall impression, it couldn't invalidate the later filing by Marks and Spencers, but it did have an effect of limiting the scope. So that's the real takeaway from this here, is that there will be clearer definitions of what falls inside and outside the grace period that then can go on to limit the scope of a later registration. So those explicit limits, having those explicit limits in place is going to be quite a useful thing. It will make it clearer in terms of what falls inside and outside. Looking at another of these sets of amendments, one requirement that is going to continue to be in place in an unamended form is that for components of a complex product, so let's take a spark plug for a car. That is a component of a complex product because the car is made up of a number of components. To get protection for such components of a complex product, those components need to be visible in normal use. That's so you can only get valid protection that way. In addition to this, there's going to be a new visibility requirement added into the regulation as part of the reforms, that all features for which you wish to have protection conferred must be shown visibly in the application for registration. What that's going to mean is that you see what you get. There is clearly going to be a difference between what they intended to mean between saying just that it had to be shown versus shown visibly. It's intended that you make the details available to the public through the publication of your design. From a practical perspective, that will mean that you need to show the features for which protection is wanted. Looking at the recitals in the reformed regulation, so the parts of the regulation that set out what the overall and underlying aims are for the reforms, are that it makes it clear that the features that are shown visibly to get protection do not need to be persistently visible in a product. They just need to be visible some of the time or in some situations. It means that if you can't make, but this also means that if you can't make out what a feature is, you're unlikely to get protection for it. It's going to require that you have clear representations to allow details to be seen. And indeed, that requirement for clarity comes in a few other places in the reforms, and Luca will speak to that a bit later as well. It does possibly call into question the value of cross-sectional view images, which are currently able to be filed at the EUIPO as part of a registration, part of an application. And that's because the interior of a product is not going to be visible. It's not going to be shown in the same way as to the outward appearance. And indeed, that may well be some of the underlying intention around why this visibility requirement is being introduced, to avoid someone circumventing design protection through, say, 3D printing a product for which there is a registration, but having a different internal structure, and so getting around the protection through the difference in internal structure somehow. An example that the EU IPO have been using on this, these images that are shown on screen here, the interior of a lift, of an elevator. The protection that is offered is in part for the lighting arrangements that's shown on the image on the left here. Because that lighting arrangement is shown, you get protection for it. If that is not shown, then you won't necessarily get protection for it, as, for example, is the case in the image on the right. Now, the interesting thing about this design is that these are two images from the same registration. So in this case, they're trying to protect the circumstance where there is light and where there isn't, and where there's a change between the two. Here, the design would likely only cover the situation where you've got both options available, but it does, at least if you'd have to split the design up or file separate things to get separate protection for both, but it does show that there is an intention here to get protection for things that are only shown some of the time. And now we're going to move on to talking about the reforms coming in for filing and prosecution. I'm going to hand back over to Luca.
Thanks, Alistair. I think I will start from the bottom and spend a couple of words on prosecution first, particularly for the benefit of those of you who are based in the US or familiar with US designs. I just want to maintain that prosecution in the EU is very different from prosecution in the US, and it is only focused on formal aspects. So the EU IPO does not perform any prior art search, and it does not examine applications in terms of novelty and individual character. It only examines the application on formalities. I will also add to this that the current limitation and possible constraints that are in place in the EU, for example, the inability to submit descriptions other than very brief description to that can guide the examiner in the interpretation of drawings, but that cannot in fact describe the object. So this inability to file a description remains, as well as the inability to submit claims or anything other than visual representations of the designs. Right, so if we move on to the changes in filing, and again, speaking of representations, this is linked to what Alistair was mentioning a minute ago. So visibility requirements, what you see is what you get. And so again, with a view of codifying and aligning and clarifying the scope of protection of EU designs, the new regulations no longer include a requirement for the representations to be capable of reproductions. This has been changed so that the representation have to present the matter in a sufficiently clear matter. So we have to make sure, applicants have to make sure that what they want to cover is sufficiently clear from their representations. Speaking of representations, this might come up as a surprise probably, but at least until the 1st of May, it is still possible to submit a specimen of the object for which design protection is sought at the EU IPO. So it is in fact possible to, as I always like to go to Alicante and show up at the EU IPO with a specimen of your design and submit this at the EU IPO. The office can know or doesn't want to deal with those specimens any longer, and so this possibility is being repealed. And as of the 1st of May, it will only be possible to submit representations. Right. What are the most important changes and for applicants, or the most the changes that will most impact on applicants? Probably the changes in the fee structures and in the multiple design filings. So with the new regulations coming in, there will be no longer a unity of class requirement. So as you may know, so far we could only bundle up several designs within a multiple design application only if the designs fell under the same Locarno class. Now, this is no longer a requirement, and so one applicant could incorporate several designs of different objects within a multiple design application. This is a nice concession of the EU IPO, but along with that comes a new limitation, and the limitation is that a maximum of 50 designs per application could be included. Another significant change is that as we will see in the next slide when we go through the new fees, is the removal of the fee discount for the 11th and subsequent designs. So if we take a look at the fees, that will be a bit more evident. But before doing that, other additional changes to the filing. So the payment of the filing fees is now officially a requirement to get a filing date. So this is being codified again. The office has, however, decided to allow for a sort of a grace period for paying the filing fee, in line with the with trademark regulations and procedures. So we can submit an application today, and today will be the filing fee, as long as we pay the fees within 1 month from today. We generally pay filing fees on the same day of the application, but this is meant to be a sort of, well, enlightenment possibly for direct applicants, or in case something goes wrong with the actual payment and the fees are not do not reach the EU IPO on the very date of filing. Another important change is that the publication fee, there will be no publication fee anymore, but the old publication fees are being rolled into the filing fees. So let's take a look at the figures now, and all will be clearer. Right. Yes, another change I forgot to mention is that the registration fee will be renamed to application fee, which was a bit confusing in the under the existing regulation, but so I'm glad this change is being made. So the application fee from the 1st of May will be of 350 euros for the first design, which, as you may see, is a mere combination of the old registration fee and publication fee. For the second design onwards, the fee payable will be 125 euros. And so, as I was mentioning earlier, there will be no further discounts for the 11th to the 50th design anymore. No publication fee is payable separately anymore. And the deferral fee stays pretty much the same. Well, it stays the same for the first design and also for the second to the 10th design. Again, no discounts anymore for the 11th design onwards. And so the deferral fee will still be 20 euros. A couple words on deferment. It is possible to, and it's particularly relevant when EU design applications are the first applications. It is possible to request deferment of publication of a registered designs. So what happens at the EU IPO is that an application is filed and examined and registered, and if no deferment is requested, then the registration is published. How deferral actually works in practice is shown in the next slide. So as I was saying, we file the application until the 30th of April. We'll file an application. The application is registered and it is either immediately published, or if an applicant wants to defer publication by payment of the deferment fee, publication is put on hold for a maximum of 30 months. The applicant may decide at any point in time to request publication of the registered design by paying a publication fee, or if no action is taken, then the design is sort of deemed as abandoned and is removed from the registered. Now, things are changing. So as of the 1st of May, with as there will be no publication fee anymore. If a request of publication is submitted along with the application, then the design will be kept off the public register for 30 months, just like under the old system. But if no action is taken by the applicant before the end of the 30th month, then the design will be automatically published. So this is particularly relevant for those applicants who may wish to file several designs within an application and then allow time for the further thought and decide which designs they want to publish at a later stage, and which designs they want to keep off the public registers. So if a design shouldn't be published, a deferred design shouldn't be published, then we will have to actively surrender them before the end of the 30th month. So again, this is particularly relevant in case deferment is requested, and we will have to make sure the applicants are absolutely aware of this to avoid their designs being published if they do not want to. Right. I think it's about time we move on to enforcement. Alistair, stage is yours.
Thank you very much, Luca. So to be able to enforce a design, it first of all needs to be granted and it needs to still be alive. One of the key parts about keeping a design alive is to ensure that your renewal fees are up to date. And there are some changes to the renewal fees that are coming in, both in terms of the amounts and when they're due. As of May 1st, the due date for paying your renewal fees will be the anniversary of the filing date within the 5-year cycle of paying renewal fees for European designs. So instead of, say, if you filed your design on the 2nd of the month, the due date for paying the renewal fee falling on the 5-year cycle on the 30th or the 31st or whatever the last day of the month happens to be, the renewal fee will be due on the 2nd of the month on that anniversary of the filing date. That also has a knock-on effect on the 6-month permitted late payment period, in that will be commensurately earlier as well. That starts running from the point of the anniversary of the filing date, not from the end of the month. So that would have to be paid by the anniversary of the filing date plus 6 months as well. As you can see, as shown on screen here, the fee amounts are changing here as well. The increase for the first renewal at 5 years from filing or from the registration date is not too much at 60 euro increase, but the increase becomes much more significant, for example, for the last renewal, for the 4th renewal, to renew for the last 5-year period to take the full term up to 25 years. Now, there will not be that many designs at the moment that are being renewed on that 4th renewal category, but it is something certainly to keep aware of, although the fees here at least should be relatively low compared to some of the other renewal fees that have to be paid in Europe, for example, on European patents. Moving on to one of the much more significant changes that's happening in terms of enforcement is the addition of a full repair clause. The existing regulation before the reforms had only a transitional repair clause in it that was kept very short and was minimal. This one's much more extensive and much more detailed, and the key parts of it are set out on the screen here. This sets out that although you can still apply for registration for certain things, you won't be able to enforce it. So what this is looking to do is to stop parties from enforcing designs that are directed to a component of a complex product. If you remember earlier, I was talking about, for example, a spark plug being a part of a complex product that was a car. And so for a component such as that, with the appearance of the component being dependent on the appearance of the complex product as a whole, for when you have a component such as that, and you have a product that is sold and used solely for the purpose of repairing the complex product to return it to its original appearance. So let's take a body panel for a car. Say you need to replace a body panel on a car. That is dependent on the appearance of the car as a whole. And when you're using that panel solely to repair the damaged car, to replace a damaged panel, if you have a registered design for that panel, you would not be able to enforce it under this scheme. The second part of this repair clause puts limits on when you can't enforce things, so bringing things back into the ability to enforce. If the first clause of this, or the first section of this repair clause, only takes effect where there is a clear and visible indication on the product that's being sold to do the repair that identifies the commercial origin and the identity of the manufacturer of that component. So if the product is not marked effectively, or not marked correctly, or not marked at all, the owner of the registered design will still be able to enforce the design fully against whoever it is that is using it, selling it, importing it, whoever's conducting any of the infringing acts. And so this is it's a balance here. This second part is a diplomatic political counterbalance, a compromise that's been arrived at through the negotiation process in the EU of doing this. We have first a section of the clause that excludes things from having designs enforced against them, and others that balances out where they're not marked appropriately to allow parties that have registrations to enforce them. There is a third part to this repair clause, and that talks about the fact that how you deal with the fact that you can't guarantee how anyone you sell a product to is then going to actually go on and use it. As long as effectively it means that as long as there's an intention that it's being sold exclusively for repair, then however the party that you sell it to then goes on to use it, it doesn't matter. You can't be, you're not required to offer a guarantee as to how it will be used. What this means is that there's a balance point that's arrived at. We have two kinds of designs that must be shaped in some way to adhere to parts of a wider product. Some of those are called must match designs or must match components, and some are must fit. Must match are components that are have to take the exact form of something to fit the very specific requirements of a component that's being fixed to, or to things that it has to be fitted to, and that's where a car body panel works quite well. And here I've taken an image from the US design question in the LKQ case that was relevant in the US very recently, to show you how relevant this is. If you're selling that sort of product, that would consider to be a must-match product because it has to fit the particular shape and contours of the chassis and the wheel rim. And so that would fall inside the repair clause, and you wouldn't, if marked appropriately, an owner of a design wouldn't be able to enforce the design against, say, someone selling this body panel exclusively for repair of a car. Whereas, for example, a wheel rim, as the example of a BYD wheel rim here is given, that only has to fit within the wheel and have the nuts that fit in the right place, and the fittings for the bolts that pass through the wheel rim there have to fit in the right place. So that's, the rest of it is able to be changed. The rest of the appearance is able to be changed, and as well as the shape. So that's an example of a must fit component where it's only the fit that's required, not the appearance. And so you will still be able to, even with this repair clause in place, even if you're not if the product is not marked appropriately, the designs could still be enforced against someone selling a spare part replacement for one of these. You could enforce a design against someone doing that as an owner. There will be grey areas within this, but if an original manufacturer provides a component that has the appearance well, provides components, we might start seeing more optionality coming in, and original producers providing more optionality and possibly seeking to get more registrations. Depends on how they see this turning out. They might offer more optionality because people might try and get round the requirements of the repair clause and the marking, and we'll see. The same repair clause is being adopted as part of the directive. And so what that will mean is that it could have a significant effect on filings through national offices. I've heard anecdotal evidence that there's a lot, well, some of the design offices within EU member states are used almost exclusively for filing of spare part designs, and so the number of filings there might be considered to drop off. We'll have to see what the reaction to this really is. One area we're also getting is that there are new rights being conferred. Parties or owners of designs are being given new rights to enforce against people who are conducting 3D printing. Now, in reality, you could already enforce rights against people who are 3D printing, but this gives specific rights to allow you to stop people who are 3D printing. And so in practice, it could be quite a useful right, quite a practical thing to have applied. A further new right that's been given is that you're going to be able to prevent transit of goods through the EU when they're being imported, say, to the US from the Middle East or from India or from China potentially. If there is registered protection in place in its destination, as well as having a European design, you will be able to stop transit through the EU of a product for which a European design is held. Now, the language of this is slightly odd. It doesn't quite match up with the novelty and individual character language that's in place for setting the validity of a design. And likely that's because this language has been arrived at to try and bring the regulation in line with various international treaties and how that is approached. So we'll have to see exactly how this is used and applied in practice, but that's certainly what the intention is. Now, along with new rights, there are new limits being placed on what you can use to enforce your European design against, and that is really to talk about fair trade use, and also brings the European design regime in line with the European trademark regime. It adds in that you can't enforce your designs when someone is seeking to parody or to critique a design, and also if someone is seeking to identify the holder of a registered design. So there are new limits being placed there as well. All right, that brings us, I think, to the end of the phase one reforms. Luca's going to briefly touch on what we can expect to happen, what we think might happen for phase two. So over to you, Luca.
Thank you. Yes, so phase two reforms, as we said, these reforms are already in the new EU regulation, but they need secondary legislation to come into effect, and so they will come into effect only in July 2026. What we know already is that we know already what a few of these changes will be in terms of priority. For example, in line with trademark practice, the priority claim will be applicants will be able to make a priority claim within 2 months from the filing date. But for the time being, the time limit will remain 1 month. In terms of examination, I think I mentioned earlier that amendments seem to be possible. So apparently we will be able to amend views for immaterial details after filing, which, as you may know, is not possible at the moment. So when immaterial details are inconsistent across views, for example, the only option that we have is to either delete views or divide them out as separate designs within the same application. as of next year, it should be possible to submit amendments. But again, how this will work in practice and the very sensibility of the examiners and how they will interpret the definition of immaterial details is still unclear. Another change that will affect examination is that the examiners will make a proposal in terms of indication of product if they're not satisfied with the one included in the application, and they will request applicants to either agree or comment on that. The current approach is that if the examiner is not satisfied with the indication of product, they will simply change it and register the design with their proposed indication of product, which doesn't really have an impact on the scope of protection, but it was quite concerning for some applicants. So finally, examiners will consult applicants before making any changes. We also know that the clarity of the representations will be assessed a bit closer, but again, how closer and how this will change is still unclear. It is worth mentioning again that a lot of the changes brought about by the updates and by the reforms is only for sake of codification and alignment, particularly with EU trademarks. So we have seen some text being moved from rules to regulations, so that it is there and it is codified, and we can get secondary legislation and so more input from the office on that. What else can we expect? Well, in terms of representations, I think I mentioned this earlier. We expect changes in the number and the formats of what we of all the representations that we can file. So currently, we can only submit 7 views for each design, with maximum 3 additional views which are unprotected and do not form part of the design. We know that there are discussions ongoing as on the updated number of views that are allowable. We do not know yet what this will be, but we also know that the EU IPO and possibly the national offices are in discussions as on the actual format of the representation. So we will likely move away from static images. Well, static images will remain as probably as the main means of representation, but we'll probably see an enhancement of in the nature of the formats available, and this will be particularly relevant for applicants active in the field of GUIs, so graphical user interfaces, and also for applicants active in virtual reality and augmented reality. We know that disclaimers will probably be reformed as well, so that the aim of disclaimers and the nature of disclaimers will remain the same, but we'll probably we'll see an enhancement in there. And yeah, and obviously guidelines will be updated accordingly. So we have more indications from the office. We can also expect an alignment. Well, this is the whole idea behind it, isn't it? So an alignment between EU and national rights. So unitary rights and national rights. Other expected changes worth mentioning is the long-awaited fast-track invalidation procedure that is likely to be introduced next year. The office, the EU IPO, is also making preparations for a design law treaty, for an international design law treaty, and also for paving the way to the use of AI and the protection of AI in the design field. Right. I think that is probably enough for now in terms of phase two changes. It's not that we don't want to give away too much. It's just that there's only so much we know. There's only so much we got to know from the EU IPO, and so we would rather avoid making false expectations. So yeah, I think that's about it, Alistair, unless you have something to add on that.
No, that's it. We'll certainly be keeping a careful eye on any publications coming out from the EU or from the EU IPO, giving us more detail on what the phase two reforms are. I'm going to briefly touch on the Design Directive before we wrap up. The Design Directive, as Luca said, has an effect on national design rights within the EU member states. In terms of what we're seeing from that, we do know all the text from that for the moment. Because that's been published and is in force, but has 3 years for the EU member states to implement within their national law. What we're seeing from that, as Luca just said, we're seeing harmonisation with EU designs and across designs within the individual member states. All the reforms, well, a good number of the reforms in the directive are aligning with the phase one reform. So all the things we've been talking to you about for phase one will pretty much all apply to the directive, to national design rights within the EU. That's also being updated to add minimum criteria that are consistent with the EU design. So minimum filing procedure, as well as minimum validity procedure of novelty and individual character. So there's nothing really of a surprise going on there. There's also a presumption of validity being added in for infringement proceedings and a few other things, but nothing surprising, nothing that extends really beyond the intentions for phase one. The only area where that's not the case is that there is some extra detail added in about exclusion and invalidity of designs that relate at least partially to cultural heritage of national interest. There is an international treaty that's currently being negotiated on that subject, but it looks like the EU have moved ahead with their own element of that already. So it may well be that this is partially used as a test for that international treaty. How that shapes out remains to be seen, and we'll see how it goes as the directive is adopted by the national members. And I think that is it for today. In terms of what we've gone through, just as a quick summary, from 1st of May 2025, the phase one reforms apply, with the directive and phase two coming into force or being implemented at a later date in 2026 and by the end of 2027. We know all the details of the directive now, and those align mostly with phase one, as I've just said. We know some details about phase two in terms of what some of the larger sort of the fixed pieces of that are. There are definitely more changes to come in the secondary legislation, and so that's one thing to keep an eye out for. Looking at what the main changes for phase one are that are effective from the 1st of May are that the fees are changing, as well as the renewal changes on renewal fees and timing of when renewal fees are due. Mostly otherwise, the reforms are modernising, bringing them up to date with current procedures, bringing them into the 21st century and dealing with how things are now. But other than that, there are distinct changes to the deferral system to shift that round, partly motivated by the change in the publication fee no longer applying. There are also direct provisions talking to the likes of 3D printing, virtual reality, and AR that just didn't exist when the original designs regulation was set out. There's also that new repair clause coming in that I spent a couple of minutes talking you through, and that will be important in seeing how that shapes out and how that is used. But that's it for the moment. Thank you very much for taking your time to listen through this. If you have any questions that come up, please do get in contact with me, get in contact with Luca, or any of your usual contacts here at Gill Jennings and Every at GJE. They'll be very happy to walk you through it, and there should be someone around who can advise you. So thank you very much.
Thank you very much.